You know, Mama, Rhonda, Charlene, Alex, all you cats in chat, all you early birds. If I was a certain someone who got caught driving in front of Judge McNally recently, I think I'd be finding myself a rock to crawl under. Post haste. Yeah. It is March 26th of 2026, and this is the Court Gallery. Welcome, ladies and gentlemen. What happens when defendants push three no-nonsense judges past their breaking point? In today's massive compilation, we're stepping into the courtrooms of Judges McNally, Aquilina, and Simpson to see some of the wildest moments on the public court record. You're going to see a defendant with a mind-blowing BAC, a fiery showdown over $58,000 in unpaid child support, and, wait for it, a guy who actually blames ghosts for cutting off his ankle monitor. Grab your popcorn, ladies and gentlemen, get a drink, and most especially, buckle up, because it all starts right now.
Give me 1 second. I'm going to take Fioretti first. Anthony Joseph Fioretti, file number 26G306834.
Good morning, Your Honor. Record James Schlock, 30720.
Okay. Your name?
Anthony Fioretti.
This is going to be a plea to operating while impaired. They're going to dismiss the Superdrone. True?
Yes, it is, Your Honor.
Is that what you want to do?
Yes, Your Honor.
All right. If you plead to operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all 4 points. License suspension or revocation in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. You understand that?
Yes, I do, Your Honor.
Did you sign, read, and understand the advice of rights form here today?
I did, Your
If you
Honor.
plead guilty, you will be giving up all those rights, and there will be no hearing or trial. Do you understand that?
I do,
You
Your Honor.
charge operating while visibly impaired. How do you plead?
Guilty, Your
Be
Honor.
operating a motor vehicle in the city of Gibraltar on Wilson near North Gibraltar on December 7 of 25 at 11:16 p.m.
I did, Your Honor.
Did you drink alcohol before?
I did.
What did you drink and how much?
Beer.
How many?
At least 1,000 second water.
What else?
Yeah,
Shots?
a couple shots, yeah.
What kind of shots?
Would have been Jameson, whiskey.
And you were involved in an accident?
I had tried to do a U-turn and I landed on the rock. Your Honor.
You had,
He was in a parking lot, too.
you think that this happened at least in part because of your alcohol consumption?
Yes, Your Honor. Yes.
Was this a blood draw? It was. Do you stipulate that this reading was accurate? 0.367?
Yes, Your Honor.
Are you on probation or parole?
Pretrial services. I have an alcohol tether. After this, I had asked for it.
No. I'm asking you right now, are you on probation or parole?
No.
What about Monroe?
To Monroe, it's pretrial services. It's being dismissed. It's being dismissed for second.
I don't,
What kind of case is that?
It's not domestic.
Anybody force you to plead guilty or promise you to induce you to plead guilty?
No, Your Honor.
Did you ever have a prior alcohol related?
2019, Your Honor.
He better get into the sobriety court that I have, or he's going to jail.
this is what you mentioned last time.
Good. I'm glad I'm consistent.
He has, been in treatment, he's been going to AA as well, but, however, he needs to get into sobriety court, he's ready to do that.
Yes, Your Honor.
Did you get printed on this case yet?
I did. After the last case, I went up to.
You ordered him last time.
Who's Thomas Fioretti?
That's my father.
So he's going to get into sobriety court?
I'm not quite sure the mechanics of that. Is that something that goes through probation?
Here's what will happen if you want to do this. And I'm not threatening you. I'm just telling you with this breathalyzer, blood result, I should say, and you having a prior, you're going to go to jail if you don't get into sobriety court.
I understand, Your Honor.
Sobriety court, we put you on bond conditions today. You'd immediately get a sober link device. You'd immediately start testing at your own expense right now, 3 times a week. You'd immediately get into treatment. You'd be going to AANA 3-4 times a week, like I ordered you to do before, right? I ordered 4 times or any combination of treatment at AA.
He has been doing that via Zoom. He has notation to that.
But throw them in person.
I
I did say in person. I wrote it down even. I don't know why these guys don't listen. Why haven't you been going in person?
Your Honor, I have a 50 to 60 hour week at work. I have my daughter 4 days a week.
I told you, did I not tell you to go in person? I know I did. Don't waffle on. I mean, you got a problem here, son. No,
Yes.
I mean, no disrespect.
I understand, Your Honor.
I don't know why I have to repeat myself and people just change their own, make their own orders. I mean, you can put on the robe if you want. I mean, I guess I could come over there. You can. I'm gonna let it go this time. I'm not gonna let it go again.
Thank you, Your Honor.
So let me finish now. You'd be going to AANA in person. You'd be in treatment. You'd be testing 3 times weekly at your own expense. You're on the sober link at your own expense. You'd have to come and meet with probation every other week, and you'll meet with me at a status review, either at 7:30 in the morning on Wednesdays or 3 o'clock in the afternoon on Wednesdays, but I'm gonna move that afternoon session to Tuesdays come May 1st. So you can either come Wednesday morning or Tuesday afternoon, starting in May. We'll put you through a bond phase. If you're compliant, and we think you're serious about getting yourself some help, we'll accept you into the program. Our grant funding will be used to pay for your testing, to pay for your sober link. If you have any deductibles, we can help you with that if you're not able to afford it. So at any rate, that's your options. And I'm gonna presume that you're going to go into sobriety court.
I am, Your Honor.
Okay, good. Sobriety court, but I don't want people in this that are just doing it either for a license or to stay out of jail. I gotta tell you, I've run this program. I'd rather do 90 days than go through sobriety court myself. I would. But that's not the point of it. The point of it is to get you some help so you don't kill yourself or kill somebody else. You get another one in the next 68 years and it's a felony.
Yes, Your Honor.
Okay? So Heather, I'm gonna take a date about 5-6 weeks out, okay?
Will it be in one of my house days?
Yeah, we'll give you a date on that. So about the end of April, I'm gonna say early May, maybe.
We have Gibraltar here on May 7th.
How about that day?
Is it a Thursday?
Yes, it is.
That'll be fine.
May 7th at 8:30, okay? But you gotta go meet with probation. Give this a lot of thought. Even if you change your mind, I'd rather you come and tell me now than start the program and fail at it.
No, I'm fully committed to the
All
program.
right, well, that's good. Okay, good enough. Good luck. Go down the hall, get your notice, then go meet with probation.
Thank you for your time.
Thank you.
Judge.
James Thomas Bowker, 260-647-449. Your name?
James Balker, Your Honor.
When did you show up here?
About 11:30.
Why are you showing up so late?
I got dropped off at the city hall. I walked to the police station.
Who dropped you off at City Hall?
My girlfriend did. I thought that's where the courthouse was. I didn't get the paperwork.
You live on Fifth Street in Trent, right?
Not anymore.
Where do you live?
Now,
Give me your address.
1971 Dorothy Lane, Gray Lane. Yeah. It's my folks' place.
Dorothy, right?
Yes.
Lane, and that's in Grayling.
Great.
What's the zip there? I mean, where'd you stay last night?
Hotel,
Which hotel?
in Romulus, America's Best.
Where'd you stay the night before?
Great.
So you drove here all the way from Grayling.
Yeah,
Did you bother to tell any of us that you live in Grayling?
yes, I did. When I had court for a loitering ticket, and they asked me where I'd be at, and where
I mean, I would have let you Zoom this. This is crazy.
well, I called and asked if it was a Zoom, but I understand that you didn't have that information, but
Well, they showed your address on Fifth Street. Is what it was.
yeah.
I mean, it's kind of getting late. Is Trenton still here? So do I. Call him. You want a lawyer?
I'd like one in.
Who's our lawyer on this, John?
It would be Mr. Schlaw.
You give this to Mr. Schloff. Explain what happened. Tell him to kind of run that one through quickly, if you would. So you go out in the hallway, we'll set you up. Jared Miracle.
Thank you, yeah.
Jared Andrew Miracle. Is he here? 20T 635-153 A and B. Do you know if he's here, Heather? I don't see anybody.
He did not check in with me, Judge.
Yeah, this is just a willful intent to delay adjudication. This guy, I sent the, I'm not going to play the games with this again. This is a 19 ticket. He was arraigned on March the 2nd of this year. I set a bond. I was probably too kind. I said 3,010%. I won't make that mistake again. I'm issuing a warrant forfeiting his bond, and I'm setting 10,010%. Bench warrant to issue 10,010%. That's on the A file. And on the B file, 1,010%. I'm not gonna play games with these guys, please. All right. What else do I have? James Bowker. James Thomas Bowker, 260-647-449. Your name, sir?
James Butler,
Mr. Shaw.
30720.
Listen, I'm gonna go ahead and first of all, does he stand mute and waive formal
He
reading?
does.
Not guilty, please entered. I can see you want an adjournment, right?
Yes, and discovery as well, please.
Right, so I'm gonna go ahead and sign that, granting the order for discovery. I'm going to set your bond, and we will go from there. So, let's see, larceny case. All right, so I'm gonna have to have you go get printed today, so we'll take care of all of that. And then I'm gonna let you appear by Zoom, okay, since you're from Grayling. All right, so Heather, make a note of that. We're gonna let him appear by Zoom, okay?
Okay, Judge.
So I'm gonna give you a personal bond here. I don't know why you weren't here before. Why weren't you here before?
He just received notice of the date, recently, is that so?
Yeah, I didn't get any paperwork.
Yeah, why did they just file a citation on February 25th of this year when the incident occurred in February of 24? So I get it. That's why it happened. I'm gonna give you, excuse me, a personal bond. I've got his new address in the file, Heather. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. I'm going to order that you not have any contact with prosecution witnesses or the victim. And I don't know who the victim is. See, they're not giving me enough information here, but no contact with the victim or prosecution witnesses. You cannot leave the state. You cannot violate a law. You must appear in court as directed. You have to go to the police department to be fingerprinted and photographed. by 2 p.m. today, okay? So you're gonna go over to the Trenton Police Department to get fingerprinted and photographed by today, March the 26th by 2 p.m. Okay, I'm filling out an order. You're going to go down the hall, get that order. If you want a court-appointed lawyer going forward, you're gonna have to fill out a petition for one before you leave. Do you work?
Not currently, that was my job.
Where did you last work?
I worked for, Edsel Estates, it was like a group home.
How much were you making?
I think that was 17 an hour.
All right. If you think you can't afford a lawyer, you fill out a petition for one.
Okay.
We're gonna give you a bond sheet. We're gonna give you an order for prints. I'm gonna give you the new court date. You're gonna go down the hall and get the court date. When is that gonna be, Heather?
That'll be April 23rd at 9:30.
April the 23rd at 9:30. Okay, sir?
Judge,
I
what's
do
this
wish you-
personal bond that you're setting?
Yes, personal bond $1,000.
Thank you.
And you can take this down the hall or take this down the hall and you'll get a copy of that and you are all set. Any questions?
No,
All right, thank you. Is that the last of yours?
Last of mine.
Is that the last of Mr. Crawford's, I hope?
No, I got it. There's a gentleman in lockup. I'm bringing out Flat Rock zooming in. He's right there. So let me get.
Is that Mr. Crawford's?
Yes. Okay. Sit down right here, fill out all the highlighted boroughs.
Wiki says.
People against Al Jahalam?
Yeah.
Salamat Nasser El Jalam. This is 26W40751. How long you been here, man?
Me?
Yeah.
USA?
No, I'm asking you.
She was a walk-in this morning, Judge.
She was a walk-in. You just walked in?
Yeah.
What time?
I walked in at like 8:30, 8:40.
Well, I gotta review this report. Your height status is revoked. Where you been?
I did not know about the party and I had no transportation. I don't drive.
Judge, just to let you know, she did. There was a notice mailed, and they also signed when she was here for her screening. She signed off on a notice in probation that was handed to her for that court date.
Yeah, and I went and got fingerprinted the same day that you guys told me to.
I'm still not following why you weren't here last week.
I didn't know about the exact date. My husband did when he went to the court. I didn't know about
We
it.
gave you the dates. We gave you the date verbally. They gave you a notice down the hall. You went and got screened. You can't just walk in and, I mean, I don't remember this enough. You can't just walk in here. I mean, it's fine. I'll reschedule your sentence, but you gotta pay a little bit more attention to this one. Well, I'll go back to a personal bond of 1,000, but you got to show up on time. 8:30 in the morning. I promise you, you're here and your lawyer's ready and you're ready. I'll be out here sentencing you. Give me a date for this one, Heather.
There should be a sheet on that, Judge.
Sorry, I don't know why I forget that. Okay, so we also have, your husband was in on this, right?
Yeah.
Wasim Salah,
sorry, Judge, we had an interpreter here for him. That was the Arabic interpreter that showed up, and they did not appear.
come on up here.
Okay.
What are you guys doing? We had an Arabic interpreter here. You guys think I'm gonna do this? You know what, you know how expensive they are? This is Wasim Salah Kayed El Riyashi, 26W840752.
Well, you're under my court representing.
What is going on here?
Well, you're on my client. Young lady here, she is supposed to get sentenced today.
Well, no, she just walked in.
Well,
Her husband wasn't here on March 18th. She didn't show up. We had an interpreter. If you can tell your husband this, ma'am,
Yeah.
if you want to agitate me, don't show up when there's an interpreter here. If you really want to agitate me, make sure you don't show up when there's an interpreter here. Those people get paid a lot of money, and the court, quite frankly, doesn't have the money anymore. And now I get this new rule that says the courts can't charge for interpreter fees anymore.
Your Honor, the reason.
I have a good mind to lock them up. That's what I have a good mind to do.
No, please don't. No.
Don't play games.
Your Honor, she apologized.
I'm not gonna do it. Because I'm a lot more courteous than some people that walk in. They just don't get it.
Well, Your Honor,
I'm
she's prepared to move forward.
not gonna, I didn't even get a chance to read the report again. I mean, you guys give me a lot of credit. I was at court to school this morning. I don't remember everything about this report. I want to read it again. She was supposed to be here 8 days ago. I don't remember from day to day. And I can't do his without an interpreter. Reschedule cases real quick before I get really agitated, Heather. We need an Arabic interpreter.
They're on the front of the file, the date.
Oh, I'm sorry. April 15th at 8:30. I'm telling you, don't show up next time. You tell your husband I'm saying this. You don't show up next time, I'm setting a bond you're not going to be able to make. And then we're going to get around to hearing the case. Tell him this. We're going to get around to having the case heard when I feel like having it heard. And that will not be anytime soon. Do we understand one another?
Yes.
Can't miss when I got interpreters here. Come on.
Thank you, Your Honor.
Thank you. April 15th, 8:30 in the morning. Go down and get your notices. Make sure we have an interpreter. People against Michael Anthony McKeon, 267-706-622. Detective, your name? He can have a seat at the table. Table. I'm sorry, John. Oh, he's got to go in there. Detective, your name?
Yes, sir. Detective Chad Jacoto with Flat Rock Police Department.
Raise your right hand, detective. You solemnly swear affirm the penalties of perjury, the testimony you'll give in these proceedings will be the whole true self you've got.
I do.
Go ahead.
Okay. On 3/23/26 at approximately 8 p.m., suspect Michael Anthony McKeon and victim Jessica Lynn Nedbold were traveling west on Gibraltar Road from I-75 when they started to argue about McKeon's alcohol consumption. The argument became heated quickly, and McKeon punched Nadell in the left side of the face with a closed fist approximately 5 times. Nadell told responding officers Houston, Murray, and Sergeant Slarb that she was in fear for her life, so she jumped out of the vehicle while it was still moving. Nadell described the vehicle as moving 5 to 10 miles an hour when she jumped out. McKeon drove off, but returned minutes later and told Nadell, "Bitch, get back in the car right now." Nadell refused to get back in the vehicle, and McKeon drove off. Officers responded to the scene, as well as Flat Rock Fire Department, and Nadell was transported to Corwell Health Trenton for treatment for her injuries. Photographs of her injuries were taken at the scene. On 3/24/26 at 9:40 a.m., Detective Jacoto, spoke with Nadell via telephone. Nadell said that she did not remember all the events due to her intoxication level. She said she had consumed approximately a half pint of vodka prior to the incident. Nadell said she remembered arguing with McKeon and that she was punched in the face, but she could not remember how many times. Nadell said she could not remember exactly what the argument was about, but she did decide to jump out of the moving vehicle because that was the only thing she could think to do in the moment. She stated that she did sprain her ankle by jumping out of the vehicle. Nadell said she has been in a dating relationship with McKeon for the last 6.5 to 7 years. They currently reside together and do not have children in common. Nadell said she wishes for the relationship to be over and does not wish to pursue charges in this case. McKeon fled the scene after the assault at approximately 10:58 p.m. Woodhaven PD was dispatched to an unwanted person complaint at a BP gas station located on West Road. Woodhaven made contact with McKeon and discovered he had an outstanding traffic warrant with Flat Rock Police and notified Flat Rock of such. Officer Murray was dispatched to the gas station and took custody of McKeon for his traffic warrant as well as the domestic violence offense. McKeon was transported to Flat Rock PD where he is booked and lodged in a cell. McKeon's criminal history shows a litany of domestic violence convictions, including June 11th of 2012, where he pled guilty to a misdemeanor charge, and October 1st of 2018, where he pled no contest to a misdemeanor second offense domestic violence. I have no further information, sir.
Listen, I want to ask you a question. Who told, I thought you said on the date of the incident that he, and maybe I misunderstood, he punched her in the face at least 5 times, right?
Yes,
And were you told that, or was one of the officers told that by the victim?
yes, they were told that.
And then later she's saying she was too intoxicated to remember.
Yes. She stated that she was struck. She just couldn't remember how many times the following morning when I spoke to her on the phone.
Based on your sworn testimony, I find the crime of domestic violence, third offense, which is a felony, was committed. There's probable cause to believe the crime was committed by the defendant and authorized the issuance of the complaint and warrant. Where were they living at?
According to the victim, they are currently homeless and living out of her vehicle at the time.
Okay. And he's already been fingerprinted, right?
Yes, sir.
Okay, I'm gonna authorize the issuance. You can bring him up. Come on up here, sir. So I find there's probable cause to believe the crime of domestic violence third offense was committed and probable cause to believe the crime was committed by the defendant. Your name?
Michael McKeon.
Michael Crawford, representing this weekend.
For purposes of arraignment,
I would like to stand and wait for more.
you have the right to remain silent, Mr. McKeon. Anything you say can be used against you in a court of law. You have the right not to say anything. You have the right to a lawyer today. You have the right to a lawyer at all subsequent court proceedings. You have the right to a lawyer if you choose to submit to questioning with law enforcement officials. Do you understand all that?
Yes.
You have the right to a probable cause conference within 14 days. At the probable cause conference, your lawyer will discuss this case with the prosecutor at the preliminary exam. If it goes that far, they have to prove that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the circuit court. If they fail to prove that, the case would be dismissed and you'd be discharged. Do you understand that?
That's right.
Probable cause conference will be April 7th at 9 a.m. That's in front of Judge Hessen. She's on the state docket this until the end of the April. Preliminary exam will be April 14th at 11 a.m. April 7th at 9, April 14th at 11. He wrote down an address on his request for a court-appointed lawyer as being on Carroll. Is that true? Do you live on Caroline?
Yes, with my parents. She is homeless. She used to stay with my parents. She don't anymore because of her children.
All right, listen.
Oh,
Stop.
okay.
Stop.
I just,
Stop.
I just.
Just stop.
What do you want to say?
Your Honor, despite how troubling the allegations may sound, my client is looking forward to returning to clear his name and vehemently proclaim his innocence, Your Honor. I don't think the court has to be concerned that he wouldn't return. He knows these are serious charges. He understands this is the third time he's being charged with something like this. But he states to the court that the court can count on him to return. He wants to resolve this.
When's the last time you worked?
Your Honor, it's been almost a year, Your Honor. My client's got significant health issues. It has made it pretty difficult for him to work. He's got a seizure condition, and he also has blood clotting problems, Your Honor. And he's been wrestling with both of these conditions since he was diagnosed with them for about a decade now, Your Honor. So it makes it tough for him to find some work. So right now he's living off of unemployment, and his parents are helping him out. But he is actively looking, Your Honor, and he's applying for SSD.
Did you find out what kind of injury she ended up sustaining? Detective,
She had contusions to her face. She had the sprained ankle, nothing that required any stay in a hospital. She was discharged the following morning.
what are you asking for?
No contact with the victim, obviously, and I would defer everything else to the court.
I'm gonna give you the bond conditions first. You cannot leave the state without the consent of the court. Cannot violate any law or ordinance. You must appear in court as directed. No contact with Jessica Nedball. You cannot write, phone, see, text, email, or communicate with her. You cannot have anybody else do any of those things for you or on your behalf. No contact with prosecution witnesses. You're not to purchase, possess, or consume alcohol, marijuana, or illegal drugs. You're not to possess firearms. You're not to possess dangerous weapons. You're required to obtain a tether. You're not to be within 2 miles of the victim, her residence, or place of employment. I heard everything everybody said. You're not to be released until fitted with a GPS tether. 50,000, 10% is the best I'm going to do. You're going to have to post $5,000 to secure your release. That might be too low. April 7th will be your first court date. You are set. Good luck. Thank you. Thank you.
This is docket 24391 FH, People of the State of Michigan versus Deshar Divine Harris. Counsel, your appearance for the record.
Good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Deshar Harris today, standing in for Mr. Austin, attorney of record.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth under penalty of proof?
Yes.
Thank you. You put your hand down. Have you taken any medication yesterday or today? Are you supposed to be on medication you're not on? Any sign of fever, COVID, or other illness? Okay, but you're not feeling poorly enough where you don't understand me or your attorney. Is that correct? So that's correct, yes.
Yes.
All right, counsel, you had an opportunity to speak with your client.
Yes, I do.
Do you believe he's oriented to date, time, and place, and does understand what's occurring?
I believe he does, Your Honor.
All right, and you, sir, have you had enough time with your attorney? If you need more time, it's fine with me. It's up to you. Let me tell you why we're here, and then you decide. So I had you on bond conditions for allegations that were made on or about November 28th, 2023. Count 1, assault with intent to create bodily harm, less than murder, or by strangulation. Felony punishable by 10 years. Same count, count 2, so there's 2 counts of that. Count 4, domestic violence, a 93-day misdemeanor. Unlawful imprisonment. A 15-year felony, interfering with the crime report. A felony punishable by 10 years, and count 7, interfering with electronic communications, a 2-year felony, and another count of domestic violence, a 93-day misdemeanor. So there's 8 counts. You were placed on bond conditions, which included a tether. And I have a bench warrant here that says you should be held in contempt because your tether has been shut off due to non-payment. And the court signed that on February 21st, 2025. So, a year ago? Is that how long we've been looking for him?
Over a year, Your Honor.
Okay, so that's the issue, sir. Do you need more time with your attorney?
Yes. There is a separate issue, Your Honor, and that is the new felony domestic violence case he picked up, which is how we have him now here.
Okay. Well, has it been bound over?
No, this occurred, let me see, on the 23rd, so it was 3 days ago. They found him at the scene. He was arrested. He's been charged with home invasion first degree, a couple counts of police officer assault resisting obstructing, possession of controlled substance, and domestic violence with a new domestic violence victim. And so then he was picked up, where we were able to actually effectuate the original bench warrant. And now we have more cause because he's committed more crimes.
Okay, but that's still in district court.
Correct.
Correct. I believe that, well, I've got it in front of me. The preliminary examination date is April 9th.
Okay. Would you like more time with your attorney? No? All right.
Is it going to be about
this.
The new one's not in front of me. You're innocent until proven guilty beyond a reasonable doubt, saying that these 8 charges in front of you. The issue here today is your tether being shut off due to non-payment. And that would be, I'm gonna amend this because I don't like when they don't put dates, and so they should give you notice of when. And so, best as I can tell, the reasons on or allowed February 21st, 2025. Any objection to that amendment?
No, Your Honor.
No objection.
And so, counsel, are you waiving further arraignment?
I am, Your Honor.
Will there be a clear hearing?
You want to do Mr. Russell make an admission to this or have a hearing on the tether violation? Judge, we wish to set this for a hearing.
All right, so we'll set this for a hearing. I'll just make a note that it was rain. We're pleading not guilty at this point. I'm raising the tag. The burden of proof here is by preponderance of the evidence being more likely than not. You have a right to a hearing, you have a right to an attorney, which I understand you understand because your attorney is here with you. You have a right to cross-examine any witnesses and evidence brought against you. You have a right to choose to bring any witnesses you want in the court order those witnesses to be present. You can remain silent. Your silence cannot be used against you. You can also choose to testify. And should you testify, you'll be subject to cross-examination. You understand your rights?
Yes.
All right. So we are going to set this. I'm going to set this for the same time as the binder. Or when do you think that's going to be found over? If it is.
The hearing's April, the examination's April 9th. Usually it takes a few weeks. I'd say May.
Great. May 6th at 11:30.
And there is one other matter, Your Honor.
And I'm going to put that's with the new file. Great. What's the other matter?
So first, I want to make sure that it's clear on the record he's being remanded until that time with this file.
Yes, he's remanded.
And then secondly, I'm asking this court to revoke his phone privileges because discovered this morning he has already been talking to the victim on the new case, both directly and through his mother.
Sir, no contact means no contact. No contact directly through third parties, no smoke signal, carrier pigeon, sign language, letters, Hallmark cards. Don't get creative because then I have to revoke your privileges and everybody's going to have to come see you, except I suppose your attorney can Zoom with you or whatever they want to call it over there. But other than that, you have no contact through any means except somebody personally visiting you. I don't know the name of the new victim for those allegations. The allegations here and found in front of me are Rosalind Tucker, Rozzlynn, Tucker, Tucker. There's no contact order. And then based on Public Act 53, there'd be a no contact order with any new alleged victims. So you understand, sir?
Yes.
Okay, so no phone or other communication privileges until we have further hearing and figure this out. Don't send any messages. If someone comes to visit you, don't write a note that you send to either victim because contempt carries with it 93 days and or $7,500. The 93 days does not go against any time you're serving on these files. So, sir, don't tempt me.
So I'm not allowed to contact my mother or anybody like that?
Nope, nobody. Not right now. When you start contacting victims, that's a problem.
I haven't contacted Rosalind at all one time.
But there's a new allegation, and apparently you've been contacting.
Erica Ellsworth.
Okay, so that would be the new. Can you spell it for the record?
Absolutely. Erica is ERICA, and the last name Ellsworth is ELLSWORTH. SWORTH.
So, sir, you can't contact. So we'll talk about who and when you can contact people and who you can contact if you're going to be nuts. But meanwhile, here's the thing. You're just making a prosecutor whose hobby it is, like teasingly, to listen to these phone calls, to listen even more to your phone calls. And then he's going to come here, and we've had people with 1,400 phone calls to people they're not supposed to contact. You could get other charges for stalking, interfering in a case, all sorts of other charges, and the evidence is in the phone call. Don't make the prosecutor happy. Start doing the right things. I don't want to complicate this case, and I don't think you want to either. So right now, there's documenting contact. You have good counsel. I'm sure he'll make a motion for contact or limited contact to limited people. I'm willing to consider that, but right now, let's keep it clean. You're remanded, no bond until further hearing. Thank you.
Thank you, Your Honor.
Did what time of the night? You say is it 9 or 1?
11:30
1:30.
on the 6th.
That was the 6th.
May 6th, 11:30.
Thank you.
April 9th is the exam.
If you need to make another bond motion, please ask for a bond report.
Yes, Your Honor.
Next is going to be David Christian.
All right, this is docket 26707FH. 26701FH. And I guess those would be the two files. All right, but there's 4 issues. There's the pretrial conference, was that held? And there's also a bond hearing. Was that held on each?
It has not been, Your Honor. We were waiting to get a report from the detective because last time we were here, I had been contacted by the jail just directly saying, hey, we've discovered he's still talking to her. Here are the calls that we had found. I let the court know at that last bond hearing, and then we decided we're going to move this out. We're going to schedule the bond hearing on the pretrial conference date, and then the intention being we'd have had the report by then. We got the report yesterday, and that's, one, it's not time for me to line up witnesses for the hearing, but 2, it's need more time for both sides to actually go through the report. So I'm asking just a brief adjournment for these. That way we have time to actually go through it.
What's the report on? Remind me.
The jail calls.
Yes, jail calls.
Yes, and the report says there have been 223 calls to the victim's number. After he was caught at the preliminary exam, he started using other inmate accounts. But to hold a contested hearing, I need to actually get the detective here, which I'm not able to because we just got this yesterday.
Nice. Counsel?
Yes, Your Honor. I'll leave that to the court. I know Mr. Christian does wish to proceed forward, but I understand people's position. Leave it to the court.
Well, have you had enough time to go through the evidence?
I'm standing in for Mr. Sarts, but I believe Mr. Sarts has had a chance to go through it, and I've had it.
But he's not here. Have you heard the calls, sir?
No.
All right, so let's move this. How much time do you need?
From the people's perspective, only a couple of weeks, but I don't want to speak for impacts.
A couple weeks is sufficient, Your Honor.
So, given the fact that it is the people's police report that just came in yesterday, I don't want to try and rush defense for what they need, but it sounds like a couple of weeks. So, anytime mid to late April, if available.
Well, I'm available, I believe, April 9th, but that might not be enough time.
It's what, 10 days, I think.
It's 2 weeks. But like I said, the people's side here needs significantly less time simply because I just have to get my detective here.
I believe we can make April 9th work. I'll check with Mr. Sarts. If not, he can reach out and change it.
April 9th at 1:30.
Thank you, Your Honor.
This is a bond hearing, SBA 53 evidence hearing.
And the pre-trial conference are just going to handle all of it together because obviously what happens with the PA 53 violation might be affecting what type of offer is made.
All right, thank you.
Thank
Anything
you.
else we need to address? You getting what you need at the jail? You getting what you need at the jail? What are you not getting?
I'm not like getting no phone like my kids. I'm not talking to my mother.
Well, sir, they have to come see you because of these.
They can't. They can't, because they said I can't get no visits. I ain't had no visits in 90 days. Since
Well, I didn't say you couldn't have no visitors, did I? You can have visitors.
Not that I-
Down on the court note, you can have visitors. You just can't make any phone calls and you can't send, if you send any messages through those visitors, then yes, you can't have visitors, but you
right
can have
now,
visitors.
that's what I did not. They never gave me my visits or my JPay or nothing. They
Okay,
took it
so
from day one.
I believe he's referring to the video visits as opposed to in-person visits. The court's order was restrictions on the phone, e-message, and video visits.
Right, they
associated
come
after.
personally see you, sir. They have to personally walk through the doors during visiting hours and come see you that way because of the alleged behavior here. So they can come see you, sir. Your attorney can let them know. They can come personally see you, but we're not doing any other kind of visits.
And just to clarify, I believe that the restrictions started at the district court level where he was convicted of doing those. So at that point, it's not allegations. He's been convicted of violating court's orders by contacting the victim through those ways. We just now have a new batch of contacts.
Okay, so they can personally come see you. Can't transfer any notes or threats through.
I haven't, John. You told me.
Okay, I got you. I don't want you to say anything against you, but
Okay.
they can come personally see you. So we'll put that on the court note. You can have personal visits. Are you getting anything? You get medication or anything else you need in the jail? Whatever you need. What else you get? What else you need? You okay? Okay. Okay. Thank you.
Thank you, Your Honor.
We're gonna do Maureen McCoy stuff next.
Is this a hideout?
Yeah. There was a plan to do that, Your Honor, and then things happened. So
Well, what's happening now?
this is a bench warrant arraignment.
Okay, got it. All right. This is docket 252774 out of H, People of the State of Michigan versus Kamari McCroy, Pigeons, Dump. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of People State of Michigan.
May it please the court, David B. Carter Jr. on behalf of McCarry Stump.
Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Thank you. Put your hand down. Sir, I have a bench warrant that has the following allegation. As of March 16, 2026, defendant failed to report to pretrial services for enrollment in violation of the terms and conditions of bond release. Is that the extent of the allegation?
Additionally, Your Honor, and I think the reason why there was a failure to appear is that on March 19th, Your Honor, Mr. McCrory was picked up on new charges that are in the district court level as of this moment.
What are those new charges?
Those new charges, Your Honor, are receiving and concealing a motor vehicle, assault. Oh, yes, receiving and concealing a stolen. 1 second, Your Honor. I'm trying to.
All right, so there are multiple charges. Okay, got
Yes,
it.
receiving, concealing, fleeing forth, and resisting obstructing a police officer.
And those have not been bound over. When's the preliminary exam?
The preliminary examination, Your Honor, is April 9th.
Okay.
And there are additional charges as well that happened on February 16th. I'm not sure what happened. Our office has authorized those charges, and my understanding is that they were sent to the court on March 10th, but not sure what happened there. So our office is looking into that right now. But there are the additional charges from February 16th, which is another receiving and concealing a motor vehicle and an assault and battery.
So that was sent to the district court?
That was sent to the district court. There are no dates yet. He has not been arraigned on that file as of yet.
Okay. So how would you like to proceed on this?
He'll admit to the allegation of failure to report because there was a misunderstanding with the next court date and what we were doing in this case. So he'll admit that he failed to do that. As far as the other allegations, they haven't resulted in a bench warrant, but obviously my client would stand mute until we figure out what's going on in those cases. I don't represent him on those other cases for some reason.
All right, sir. As of March 16th, 2026, failure to report to pretrial services for enrollment. How do you plead?
Guilty.
Did anyone force, threaten, or coerce you to plead?
No, ma'am.
Did anyone promise you anything that caused you to plead?
No, ma'am.
And you pled of your own free will after talking with your attorney?
Yes, ma'am.
And you've been satisfied with the representation of your attorney?
Yes, ma'am.
And you knew I gave you bond on January 14th. I gave you a $5,000 PR bond. And I told you to report as directed by pretrial services, including any testing they wanted, BPTs or drug testing. And you were supposed to appear for all hearings and proceedings. And the next court date that I have on the bond was 11 February 2026 at 11. Did he show up for that? Did he show up for that?
He did.
So
and I contacted pretrial services when they contacted me and said, hey, your client hasn't started that. And I said, well, he showed up for court. And that's where the confusion started with my client and pretrial services.
okay. Sir, you have to show up. You have to go. Do you know where pretrial services is?
No, ma'am.
No.
The
Well,
only option I found is pretrial services on East 2nd Street.
Yeah, I'm serious.
279 miles due south.
Sir, when you're on bond conditions, when you are free, figure it out. All right. Here's my confusion. I let you out on bond. And one of the things that you are clearly, I think, knowledgeable about is you're not supposed to violate the law, which is also a violation of bond conditions. And now I have 2 files that are coming up to me. And I don't want you to talk about that, but I want you to know that I can toss this violation, doesn't mean anything. I understand your confusion, you're gone. But I also know you're old enough to know the law and to stay out of trouble. Because you had a lot of years where you were not in trouble. And suddenly I got a whole bunch of stuff coming in front of me. So that's a concern. So what was so hard about checking in? You were just lost and didn't know what to do?
No, I actually forgot, Your Honor. And I had just got a house and a phone number and I forgot to like contact them and everything.
I think what happened, Your Honor, and I'll be frank, is my client spent, he's got a lot of time in on this case. And it on that day when you gave him a PR bond, I think when you verbally said a PR bond, such and such, everything else, just he was so ecstatic to get out, because when he got out, he worked with Peckham, he got a job, and he has a job. He was working when he got picked up. They found him housing. He's getting into housing. And that's what I think happened, is I think he was just so ecstatic that he was getting out on a PR bond that he didn't follow through with checking in at pretrial services, because he showed up at his next court date. I didn't realize he wasn't showing up with pretrial services. I even indicated that to I think Greg down there. And in the meantime, because he had been locked up so long, he ended up getting a new phone, and I had a hard time contacting him by phone to let him know that. But other than that, he showed up at every court date in between.
On behalf of the people, what is your recommendation? He is guilty of violating bond. Well, let's talk about what happens here.
Correct, Your Honor. At this point in time, the people are concerned with letting the defendant out again. We are now, as I stated, Your Honor, there are now, and I understand that they are only allegations, but there are 2 new allegations of the same exact charge that we are currently in front of, essentially occurring in front of your honor on. This case also involved a potential theft of a vehicle, but there was an individual that was able to call him out prior to that. We now have 2 receiving and concealing motor vehicles that have happened within the 2 months that Mr. McCroy Stump has been out at this point. The people are concerned, Your Honor, that if he is let out on another PR bond, he is going to have more violations, more motor vehicles, Your Honor. So the people would be asking for 10,000 cash surety at this time, Your Honor. Response.
Well, I would indicate to the court that let's look at this case only. He's got so much time in on this case. I'm asking the court to give him a shot at another PR bond. But understanding he's got a $3,000 10% bond that he has to post down in district court on these new charges. So he still has skin in the game with having to show up. But if you set up a bond at $10,000, he's not going to get out. He's going to sit. He'll sit until trial.
Sir, what is your new address? You said you had a new address?
Yes, 2510
Risedale. Is that a house or apartment?
apartment.
What's the number? Okay. And is that Lansing?
Yes, ma'am.
What is that?
48911, I want to say.
Who lives there with you?
Nobody.
And what about your job? Can you go back to work?
Yes, ma'am.
So, my understanding with one of the offers at least was that you were going to get hired to earn a non-public record. I don't know what the offer is going to be or if there's going to be an offer with new files coming up. How old are you?
19.
You like that jumpsuit?
No, ma'am.
Are you sure?
Yes, ma'am.
You have any family in the area?
Yes, ma'am.
Who?
I have brothers and sisters.
What about your parents?
My dad is in Indiana, my mom's in Georgia.
So why are you here if they're not here?
Because when I had got locked up, they had left.
Are you in contact with them?
Yes, ma'am.
Do you have a car?
Mm-hmm.
How do you get to work?
The bus sometimes, or I take an Uber.
I don't know what's going on with you, but you're 19. Sorry your parents have moved away. I don't know what kind of support your siblings are, but you keep getting in trouble. The county or the state is going to give you a bed. It isn't very comfortable. Some food. It isn't very good. And whatever color jumpsuit they want to give you. Oh, and you get those Crocs too. If that's the kind of life you want, you keep breaking the law. If you don't want that life, and you want nice things, and you want to live up to the magnificent potential you were born to, then stay on the right side of the law and get all of these files behind you one way or the other. Start making amends. Because there's a fork in the road here, and it goes one of two ways. You rehabilitate yourself with a lot of help that we provide, but you got to do the work. Or the other road leads to jail, prison, and maybe a body bag. None of those options are good. And I hope you think more of yourself than taking those options. But the choice is yours. It is not mine. It is not law enforcement's. It is not the prosecutors, your parents, your siblings, or your lawyers. It is your sole choice. Who do you want to be? What kind of man do you want to be? What kind of citizen do you want to be? What kind of son and brother and maybe father do you want to be? Those are all choices you need to make. And I hope for your sake and everybody else's, you decide you are valuable, that you are worthy of greatness, and you shoot for the greatness, not the Department of Corrections. You have decisions to make. So here's what I'm going to do today. I'm going to give you a $25,000 PR bond. You're held on the others. So we'll see what goes on. You will have a jail GPS tethered. Now, if you cut it off, that's another felony and a whole lot of money. If you don't charge it, it'll be brought in. If you commit a crime, we will know exactly where you were and where you were not. There is an indigent grant. If you are eligible for that, then great. If not, you'll have to work a little harder and pay for it.
I have a question.
Yeah.
How would I know the indigent grant?
Because we have wonderful people over in the jail and they'll help you with all of that. And also, your attorney knows about it. There are a lot of good people who are working for you, but you have to work with them, not against them. Okay? You shall not use, possess, consume, or be in the presence of illegal drugs, alcohol, or drug paraphernalia. If you have any prescriptions, you'll show them to pretrial services within 24 hours. Take any psychotropic medication, if any, as prescribed. You'll follow all your doctor's recommendations. You'll PBT and or drug test as requested by pretrial services, law enforcement, any court officer, or family members you may live with. You'll not only have in your possession or under your control any weapon, gun, ammunition, imitation of a weapon. You'll not be in the presence of anyone who has any contraband whatsoever. You will not be in the presence of any known gang members. You'll not wear any gang colors, insignia, or gang tattoos. You will remain residing at your residence. I am impressed that you have a residence. A lot of people your age get in trouble and they're homeless. So you are making some strides that impress me. Keep impressing me, sir, because the opposite doesn't go well. You should also probably check into Lansing Community College. You graduated high school, right?
No, man. I've been into the adult education center.
Well, great. Do that. Because the only thing that someone cannot take away from you, besides your name, is your education. So don't just check in and sign up. There's also a program at LCC where you can get high school and college. I don't know if you qualify for that or not, but you can get 2 for 1. I don't know with all this going on if they will accept you or not. But figure it out. Pretrial services can help you. You will appear for all hearings and proceedings. Our next court date, I don't know which process are those other cases.
Yeah, I would suggest that, one with the.
So the preliminary examination for the case that he has been arraigned on is set for April 9th. I'm not sure, like I said, I'm not sure what's going on with the other case. I'm going to, as soon as I'm done today, go up to my office and figure that out and get that authorized and arraigned ASAP.
All right, May 13th at 11.
I'm sorry.
May 13th at 11, does that work? And then if we need to move it because we want to have all files at once, we move it.
That's what I was going to suggest, is like a control date, and then once we get
and then
May 13th.
You need to advise pretrial services and your attorney of any address or phone change. Do you have a phone number?
Your Honor, I may be in trial on the 13th in Jackson on a homicide.
Okay. Let's take the next week. 20th, May 20th. May 20th at 11. If we need to move it again, let's do that, but I don't want to put it too far out there. So, sir, do you have a phone number?
Yes, ma'am.
Okay, is your attorney have it?
No, I want to get it from, go ahead, 517.
316-6012.
Right. No change. You need to let pretrial services in the court and counsel know within 24 hours. What hours do you work, sir?
I work part-time now, so it's sometimes from like 9 to 12. And then
Is that in the morning?
Yes, ma'am.
Yeah, 9 to 12. Do you work afternoon?
No, no.
Do you work evenings?
No, no.
Great. You're going to have a curfew of 10 p.m. to 7 a.m. So you need to be in your residence at that time.
Yes, ma'am.
You will appear for all hearings and proceedings. The next court date in front of me is May 20th at 11, where we're going to take up all of your matters, and your counsel may move it, so stay in contact with him. And pretrial services, you end up coming to this building, and then pretrial services is in the basement, is that right?
No,
Probation, or are they on the first floor?
third floor.
Okay.
3R, right?
You're on the
Is it
first
3R?
floor, I don't know, so third floor? Okay, so go to is it 3R? 3R, so the elevator is gonna, so here, I'm on third floor, when you're in the elevator, go to 3R. That goes to the other side of the building. That's where pretrial services is, okay? So within 24 hours of your release, as long as it's through if it's on a Friday, you'll report Monday. If it's on a Monday, you'll report Tuesday, okay? Pretrial services, and engage with them. You will not have any contact with any co-defendant, if any, or a victim on any file. And no contact with anyone on parole or probation or in MDOC, Michigan Department of Corrections. If any time needed, you'll work with counsel to verify your address, maintain housing, and obtain employment, administrative counsel, pretrial services, and as directed. And also, I want you to enroll in school to get high school or GED. You need to be busy, sir. Anything I've told you to do, you're confused about?
No, no.
Anything I've told you to do, you think you can't do?
No, no.
Sir, this is for you. It's not for anybody here. In fact, it's painful for law enforcement. They got to keep arresting you. Don't give them a problem. Don't make them arrest you. You like riding in that sheriff car?
No.
But don't ask for a ride. Stay law abiding. Not comfortable in the cage in that backseat, is it?
No.
Well, then let's stop it. Stop the cycle. Whatever's going on with you, let's get you some help. You got to help yourself, okay?
Yes, ma'am.
Now, do you think you need to work with community mental health? Is there something going on I don't know?
No, no.
Well, if something happens and you really feel the need, they have phone numbers you can call. Get in, talk to someone. Don't commit another crime. Got it?
Yes, ma'am.
We'll make sure you read a copy of all this. I'll see you in a few months.
Thank you.
No new files, sir. Got it?
Yes.
Thank you.
Jail credits.
How much jail have you served on this?
When did you get
When you
picked
got
up?
picked up on this
On the 20th.
bench for?
20th, and today is the 6th, so 26th, so that would be actually 7 days.
Okay, 7 days credit for 7 days. Good one.
Courthouse case versus Larry Matthews. Madam Attorney General, if you state your name, please.
Oh, sorry, Judge. Carrie Angie for the people.
Thank you.
And Assistant Brendan Nick Buckovich for Mr. Matthews.
All right. Your name, sir?
Larry Matthews.
All right. What are we doing?
Mr. Matthews indicated he'd like to speak to you, Your Honor. I did advise him against this. However, he would like to speak to you at this time.
Speak to me?
Yes, Your Honor.
For what purpose? What do you want to say?
I have evidence in my case. I wrote a letter also and submitted information into my case.
That, but what do you want me to do with that?
Well, this case is for year 2010 through 2013 for a total of $58,000 in child support. So for those 3 years, it's calculated up to $1,100 a month. At that time, I was on food stamps, and that, that amount would not have been an accurate child support amount. Now, as far as the warrant, I went to court in Tennessee in September 9th of 2021 on this matter, and a judge ruled on it. So I wasn't aware of a warrant or anything like that. I've sent certified mail.
Told all of this to your attorney because you're telling us, but I can't do anything.
I have. My attorney refused to work for me as I needed him to.
Oh, so with your law degree, you were gonna try to tell him what he needed to do.
It was
some of that stuff he couldn't do. So he's not working for you.
Forgive me, Your Honor, for addressing the court, but it's not submitted any information that would get me home to my family. I had my employer has advanced me $10,000 towards my bond, get home to attend to my business on Monday.
I did send information that was provided to Ms. Gaines by Mr. Matthews Lights to AG Williams this morning. Obviously, AG Williams is not the on today, but that was the attorney on the docket, so that's who I sent this information to and communicated with earlier this week about Mr. Matthews.
So you actually did your job, right, Mr. Buckovich? But nobody appreciates it. I got you. Anything else you want to tell me?
Yes, sir. I was extradited from Texas. From here, it's been a total of 27 days that I've been incarcerated. The letter that I wrote to you explains a lot more in detail. I have $10,000 for my bond so that I can be released to get back to work. My wife
requires 25%. So if you're at 58, I'm going to be somewhere around 16, 17,000.
14,500.
I have your bond in this case set at 16,80462.
Yeah, the numbers that were submitted for the total is about 3 different numbers. And I'm not sure which one is correct. I received a letter in the mail.
Well, if you paid the 16,000, it's going to go to where sport should be anyway. So I'm not changing the bond.
Right.
Anything else?
No, sir.
What do you want me to do with this case?
Yep.
I just opened that to the floor, I guess. I don't know.
You asking me? You asking me?
Huh? Whoever wants to answer me.
Well, I believe that the 10,000 should be accepted.
Okay.
Home to my wife and son.
10,000. Then you need to come up with about 6,000 plus more.
This case is between the years of 2010 and 2013.
Okay. And somehow those children had to survive without you paying your child support.
It was only 3 years. My son is 30 years old now.
Okay, and it's owed.
And I want to pay it, sir. I do want to pay it. Can I start with the $10,000?
We will take the 10. Then you got to come up with 6. I told you that. I mean, I'll keep repeating myself as long as you want to keep repeating yourself. I don't have a problem. I got all day.
I mean, you just sign this form.
When is the court date?
He'll give it to you. Yeah, I can do it.
I've spoken to him whether he's still just
What? We wait a little longer, he'll probably have 12,000.
What?
Yeah, the longer we go. She's a lot of money. I'm thinking.
This is the offer we talked about on Tuesday when we were in jail. We're waiving up. If you pay the certain portions down, they will reduce the charge.
To do that.
Wow.
Suspects is sure. He'll be waiving, Your Honor.
Pardon?
Be waiving, Your Honor.
Okay. Right. That was almost lunch. So you're waiving your right to a preliminary examination?
Yes,
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
yes,
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
when would the hearing be?
Pardon?
When would the hearing be?
Soon. I will set a date.
Okay,
I mean, this isn't a negotiation. You want to waive or not?
well, I
You
do,
want to waive or not?
I do, but I don't understand all the court proceedings because
Okay, and that's why
I'm not a criminal.
to listen to him.
He's been doing this for 2 years. And I'm not a criminal.
It's 2 years long. Do you wish to waive your preliminary examination?
Yes,
You will also waive?
Yes, Judge, thank you.
Thought everybody was. All right. Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Mr. Bukovich, with your 2 years experience, can you do this part? Go ahead.
To waive formal reading the information and stand mute as to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial in this matter will be set.
1:30, Judge Slay.
Here's your date, April 9th, 2026, 1:30 before Judge Slay.
well, I have one question, Your Honor. If I pay the bond to get out, I reside in Tennessee. That's where my home is. Will I be allowed to go home and then come back to court?
If you pay the bond, you're gonna have to stay in Michigan until the court gives you permission. So now, this having been waived, Judge Slay would be the one that you'd have to ask.
Well, where would I stay here in Michigan?
Where would you stay? Well, we're providing accommodations at this point.
Well, once I get out.
I don't make hotel reservations. I don't push. Oh. Can't stay at Childers' house. This thing.
Listen, this is my life.
I understand that, sir, but you're asking me questions I can't.
27 days incarcerated for no reason.
No, there is a reason. You didn't pay your child support. Now, if you want to keep going, I can do something else with the bond, but I think we're done here. Thank you.
This is my life, man.
Yes, I know. And you've taken part of mine that I will get back. Goodbye. Goodbye.
Judge Simpson, if I could just say, and I think he may be too proud to say, Joy Gaines, Senior Assistant Public Defender, his wife contacted me, and either today or yesterday, I mean, their son was murdered within the past year, and this is the court period time. So I think he is under a level of stress.
I understand.
So I just want to apologize.
It's a motion, a way to do that.
Yes, yes.
Just to listen to Mr. Bukovich.
Yes.
Mr. Bukovich could have gotten that before the court. It could have been addressed. He wanted to handle it his own way. So my condolences to his family, but this isn't the way it's done.
Yes.
Thank you.
Yes, sir.
Courthouse case, People versus Derek Jones.
Morning, Your Honor. Alex Chapel with the people.
Oh, there he is.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Jones. We are in.
Hang on. Right now, I'm muting.
Yes.
Jones, is there a way for you to unmute yourself or? Got it. Okay. State your name, sir.
Derek Jones. And Your Honor,
Thank
I'd like
you.
to talk to you for a minute when you can. And my lawyer.
I'm sorry?
I'd like to let my lawyer know something too.
I didn't catch the last part of what you said. You want your lawyer to do what?
I've been waiting to talk to my lawyer. I had my parole. This case is holding me up.
Okay, I got you.
I understand. I was finally able to get an appointment to meet with Mr. Jones on April 1st. That was the first available date. We have been playing, well, I don't know if we've been playing tag, but finally I got a response.
Got a meeting with him April 1st.
April 1st, yes. I think at 1 o'clock.
So he's.
I went with him yesterday too.
Hold on. All right. So you're looking to adjourn to try to get this solved so that that will clear his way on everything.
Yes, and I have been actively speaking with the prosecutor so that when I go there, I hope to have everything he needs to be done when we come back to court.
Okay, so if you've got an appointment on the 1st, let's do the 9th. That'll give 2 weeks for the writ.
Thank you.
So my understanding, sir, she'll be up there to see you on the 1st. I'm going to adjourn your case out to the 9th. Hopefully we can get it resolved then and move ahead, okay?
Is there any way you can let the parole board know? That way they don't flop me?
That's something you need to discuss with your attorney. I can't.
If you would like, I will write a letter to the parole board and let them know.
Yeah, because I do my parole date is May 26th. So if you can write them a letter, let them know that it'd be on the 9th, be taken care of.
All right.
Thank you, Your Honor.
Thank you. Thank you, sir.
Thank you.
Bond continue. Court does call the case of the people versus Stefan Bruce.
Your Honor, David Cook for the people.
Yeah.
David I. Goldstein appearing on behalf of the defendant. Your Honor, my understanding is the defendant is the Wayne County jail. Shouldn't be, but he is. They can't find a tether to put on him. He's been there for 3 days waiting for a tether.
Can't find a tether?
It's Wayne County, Judge.
Oh, okay.
So if we could have
We got them all over the place.
I know you do. You want to loan them? You want to rent one to them? So
Oh. Right. So you need an adjournment on
1 week, Your Honor. Yes. I'm sorry, I didn't do it.
I have to do.
Okay, let me check that.
They'll have to rid him
At the 9th.
still in. Yes. That'll work for you.
Yeah, that's fine.
April 9th, 2026, 9 a.m. I do need a brief.
I'll get you one right.
Thank you. Court does call the case People versus Chidera Kiji.
Your Honor, David for the people.
This is Public Defender Jay Bellinger on all matters not ending in 1678, Your Honor.
Morning, Your Honor. Jonathan Sachs in the matter ending in 1678.
Oh, by process of elimination.
I know you love that.
All right. And where are they? Are they? Oh, they're coming in. Morning. We're looking at them spreading rumors you weren't showing. Oh.
Can you state your name for the record?
Chidera Bennett Taikiji.
Thank you.
Thank you. And Your Honor, we are asking for an adjournment today so that we can get or the health treatment court.
Okay, so you need at least 3 weeks.
I think so. We'll start with that and hopefully we'll have them done by then.
All right, I'll adjourn these matters then to April 16th, 2026, 9 a.m. Bond continued.
Thank you very much. I'll get this in today, okay?
Thank you, Judge.
Gotcha. So this was court calls the case People versus Diamond Buyers. Of course she is.
Morning, Your Honor, please.
Good morning, Your Honor. Edward Lucas on behalf of Diamond Buyers, who is the program.
You want all matters?
I am.
Are you?
I am as of yesterday.
Name.
Diamond Buyers.
I messed.
Buyers was before me yesterday.
I know we've been working to try and turn herself on, but
Buyers thought she was going to jail.
I did tell her she wouldn't.
Huh?
Told her she wouldn't.
Told her she wouldn't?
Yeah.
Really?
She had to pay a bond on another matter.
She did.
She had to get arraigned on this case.
And
up here by on all those.
Up here on 2 other cases, had these other 3.
She had some bond money with her,
Really worried.
Yes.
but we are working.
No, you wanna know how I know? She was telling my clerk she was really worried.
Oh,
Was asking them, was she going to jail?
How many times did I tell you you weren't going to jail?
1,000 times.
If I had known that before, she would have gone. No, I'm kidding. All right.
Talk almost daily, and we're looking to resolve these cases, but I think an adjournment would help trying to come to a global resolution.
16th work for you?
That would work, Your Honor.
All right. That objection will adjourn all these matters to April 16th. 2026.
Thank you.
Thank you. Court calls the case of the People versus Hatchet Kaba.
Good morning, Your Honor. James Mafelsky on behalf of Ms. Kava, who is being brought out. Can you state your name for the record, please?
Khadijah Kaba.
That's right.
Your Honor, all discovery is in. We'd ask the court to set this for preliminary exam. And I have a very simple and brief bond request before we conclude.
People have their witnesses available the 7th. Preliminary examination in person will be set April 7th, 2026, 9 a.m. before Judge
Perry.
Judge Perry.
Thank you, Your Honor.
Says the bond.
Your Honor, my client previously posted bond, but because this case turned into a violation of probation in 14B, she is held without bond in 14B. So I would simply ask the court, so she can get credit for her jail time, to add maybe another $100 bond, so that while things are being worked out.
Her bond set at in this case.
I see it as, I think, a 30,000, 10% that I believe was posted. But because again.
Posted the cash surety, she did.
Yes. And it looks like she's being held at least until.
Bond amount will be set in the amount of $50,000 cash surety.
Thank you. Thank you, Your Honor.
Court calls the case of the People versus Troy Swope.
Alex Evelowski for People.
David I. Goldstein, on behalf of the defendant, Mr. Swope is in custody, Your Honor.
It's a test that went out, right?
Yes.
State your name. Troy Swope. We received a confirmation test. Did you see that?
Yes, Your Honor.
If cocaine was confirmed positive as well as the fentanyl.
Yeah, I'm assuming it was a mixture, Your Honor.
Yeah.
Your Honor, first let's deal with the issue of ECC. I do not have complete discovery yet. I do have some, but I have had an opportunity to discuss the matter with Mr. Chabalowski. We need a week to further explore the matter, and also Mr. Chabalowski informed me that there are potentially additional charges coming against this defendant, probably a misdemeanor, but there are possibly, and that we'll need to factor that into our discussions.
All right. So you want me to adjourn it?
The 9th, I think you said, was the next date.
Yes, a week. Well, I have the 2nd or the 9th.
Well, when I said the 2nd a minute, you said that wasn't available, I thought.
Pardon?
On my other case, I thought you said the 2nd wasn't available.
Only because I think we had to, there's a video read.
Oh,
we had to do a read.
Oh, Mr. Bruce will be out. He should be out as soon as they find it. Well, look, I should.
I know. Not me.
Yeah, right.
I had to go.
Yeah, two weeks to find a tether is a little bit extreme, Your Honor, but I understand. So it's Wayne County. Yeah.
But I can go to the 2nd or the 9th.
I prefer the 2nd, Your Honor.
Probable cause conference will be during April 2nd, 2026.
Your Honor, I would like to address the issue of bond.
Yes.
Okay, Mr. Swope had posted bond. I don't remember if it was a PR bond or not, but he was out. Mr. Swope admittedly has a drug problem and was being treated with Suboxone. And as long as he was taking the Suboxone, he was not taking any other drugs. However, he had an accident, was it?
Yeah.
They took what he had an.
So I got out and I didn't have my insurance in time.
Oh, that's right.
So
Okay. Right. So when he got out of jail, he went to get a prescription for the Suboxone. They wouldn't honor his insurance because it had to be reprocessed because he was in jail. And he admitted that he slipped. And for the one time, the cocaine, which had fentanyl in it, obviously he was using it for the cocaine. Your Honor, we would ask that you would consider reinstating his bond. He is back on the Suboxone, or would be if he wasn't in jail. And as long as he takes the Suboxone, he is drug-free, otherwise drug-free.
I'd have to see some proof that he is in treatment, that there's some programming. Because he's got a deadly cocktail that's come back twice. And so he's going to end up dead or he's going to end up in jail. I'd rather have him in jail.
I do have proof though.
Can you get that to me?
Yeah.
Okay. Good. Get it to me. Okay.
So at this time, I'm going to deny the bond will continue as denied. Court calls the case of the people versus the Chardonnay Sanders.
Rob Dowd is prosecuting attorney for people on both cases.
Good afternoon, or good morning, Your Honor. Marcia Craich on behalf of the Sanders.
What?
Good morning, Your Honor.
Oh.
I'm excited.
Up there, you explored the world, thought the place was better than Washington County, and you're back.
Yeah, it was a long journey, Your Honor. But I'm glad to be back. I'm so happy to be back.
It's like Groundhog Day. It's just going to repeat itself.
Hi.
Well, it's good to have you back.
Thank you.
Your name, ma'am?
The Chardonnay Sanders.
Thank you. You need an adjournment?
Yes, please, Your Honor, to making sure I have all discovery and then to share that discovery with my client. Additionally, my client is.
The 9th work for you?
I'm sorry?
The 9th work for you?
Yes, it will, Your Honor.
Probable cause conference will be adjourned April 9th, 2026, 9 a.m. Bond.
Well, my client's asking me to make a bond modification argument, Your Honor.
Okay, go for it.
Okay, thank you. My client's currently charged with 2 cases that are very serious. She understands that, but those are allegations. She'd like me to relay to the court that she's lived in this county her entire life. She has some children that she needs to ensure that are being taken care of. During this time, she has been working on her case service plan for her neglect and abuse case, and she's doing well. She does not have a job at this time, so the bond amount that in each case is a financial hardship for her. She's willing to do a GPS tether. She understands that she needs to come back to court, and she has family in the area that she could stay with and support. So we're asking to lower the amount to a PR if possible and or a 10% component, Your Honor. Thank you.
Sponsoring the people.
And I would ask bonding saying she failed to appear on the child abuse case and this court. Second charge, she got picked up and she was here before you was assault, very probably murder. She allegedly stabbed her mother's girlfriend in the arm, causing a lot of damage.
My client tells me that she had her cell phone stolen from her, and that's why she missed her court date, Your Honor.
Okay. Thanks for letting us know. Given all those circumstances, I'm not going to reduce her bond. Her examination is coming up, and we can certainly address it at that point in time after the testimony is heard. Motion for bond reduction is denied.
Thank you, Your Honor. Thank you.
Court does call the case People versus Robert Jovashevsky.
Your Honor. Assistant Public Defendant Shanazi Carriac really on behalf of Mr. Jovashevsky.
Chesky. You don't know.
I do.
Yeah, your client. How come I know and you don't?
Bad with names.
Sir, keep looking ahead.
I'm sorry, Your Honor.
State your name.
Robicheski, Robert.
John, we'd be asking for an adjournment today. We would be submitting a competency evaluation.
You're gonna be requesting a forensic.
That's correct, Your Honor.
Probable cause conference will be adjourned April 9th, 2026 next. On continue.
We will take that to be done in person, ma'am.
Say that.
Can we request that the competency exam be done in person and not over the video?
I can talk with them and see.
Would you please, because I can't hear and it presents a big issue and I don't want to be uncooperative.
Okay.
All right.
Did you want me just to order A or did you,
I have the report.
or you have the, do you have the form?
I-
Because I can order it today if you
Perfect.
want.
Okay,
Okay.
yep, I'll.
I won't have to print it out. A forensic evaluation will be ordered. I'll set a competency hearing for the 25th, 2026, 9 a.m. We can move that date up if we get a report for then.
Okay.
Okay, Bob, we'll continue.
Your Honor, I apologize for my behavior to you, sir.
Not a problem. Take care of yourself. Court calls the case, People versus Reese Palmer.
The people?
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Ms. Palmer.
What's your name for me?
My name is Reese Palmer.
All right. I have before me two plea forms indicating that Mr. Palmer is going to plead guilty to 2 charges of retail fraud, 2nd degree, the 1-year offense.
That is correct.
Right? Okay. Those are, well, on the one case, 123-1072, that's, I think, the stated count.
That's
right? Because we brought that one in.
That is.
And on the other case, that's an added count 2 with count 1 being dismissed. There is an understanding that, and there's no other understanding. That's the court's full understanding of the agreement.
That's correct, Your Honor.
Is that correct, Ms. Gaines?
Yes, Your Honor.
All right. Can I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yes, sir. State your name, please. Bruce Palmer.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to 2 charges of retail fraud. Is that correct?
Yes.
All right. Now, those are misdemeanors punishable by up to 1 year incarceration, $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than 2,000, that becomes your maximum fine. You understand that?
Yes, sir.
All right. Still wish to plead guilty to those charges?
Yes, I do, sir.
All right. Starting in the case ending in 1960, to an offense occurring on August 31st, 2025. To that charge, how do you plead?
Guilty.
All right. To that same charge contained in the case ending 1072, occurring on June 28, 2023. All right. Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, I did.
You have any questions regarding any of those rights?
No.
All right. Look at copy on the podium. Look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No probation, no parole. I haven't had a ticket or nothing in 8 years, sir. These cases is 2 or 3 years old. I was in a bad place, sir. I was homeless, but now I'm in a better place. I just want to get this behind me, sir, and get back home.
All right. We'll work on that, okay? All right. Has anybody promised you anything other than what's been stated today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will,
Yes, sir.
and because you believe that you're guilty of these offenses?
Yes, sir.
Okay, starting with the case ending in 1960. On the date of August 31st, 2025, at the location of 3825 Carpenter Road, that being the Meyer store, what'd you do on that date that makes you think that you're guilty?
I took a bunch of shirts, sir. I was homeless and I needed clothes.
And you tried to walk out without paying for them?
Yes, I did.
And these items you took, Meyer had offered for sale?
Yes, they did.
And you didn't have anybody's permission to take that, did you?
No, I did.
On the other case, on the date of June 28, 2023, again at the Meyer store at 3825 Carpenter Road in Pittsfield Township. What happened on that day?
I took some liquor, sir, because I was staying in the tent. I need to get warm. So I took a couple bottles of liquor.
Okay. And I think this one is actually on a prior offense. Had you previously been convicted in 2018 of a retail fraud? You recall that?
I don't know, sir. I was in a,
Let me ask it this way. You, previous to 2000, you had been convicted of retail fraud before that, right?
yes.
Okay. All right. Mr. Peterson, if I accept your plea, and you commit misconduct between the time of my acceptance of your plea and the time of sentencing, you would not be entitled to withdraw your pleas. You understand that, sir?
I understand that, sir.
Okay. And the court would not be bound by any sentence evaluation or recommendation. You understand that?
I understand that, sir.
All right. Counsel, have there been any other promises, threats, or other indications which have led to this?
None from the people?
No, thank you, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, sir.
I will, in the case ending in 1960, I will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be April 8th, 2020 for me. And
May we address bond, please, Your Honor?
one moment. And on the other case, I'm also going to refer him to probation for a pre-sentence investigation and report. Sentencing will be April 8th, 2026, 9 a.m.
Street.
Yes, that's about. Where's he? Christian, where are you living now?
I'm on Ecorse Road, 111 Ecorse Road in Ypsilanti.
It's not his paperwork that we submitted, his address,
Yeah, no, I got it.
but he
Oh,
has his own
We're in township.
place.
Yes, I have a place, sir. And I'm in a good place now, sir. I'm just trying to move on with my life. And like I said, I didn't know these cases was behind me. I would have had them taken care of before I came, before this even got to this matter.
Okay, and
He's receiving Social Security now, Your Honor.
I'm aware of Mr. Peterson's bid. And so, Mr. Peterson, let me ask you, if I let you out, you're gonna make sure to get over to my probation department?
Yes, I will, sir. I'll be there.
And you're gonna get, because both of these cases are before me.
Yes, sir.
Gonna get yourself back here?
I'll be back here, sir. On court date, I'll be here.
Hold on, is your balance okay?
Any response to the bond modification in the future?
No, Your Honor.
I'll grant the motion. Mr. Peterson, I'm gonna let you go home.
Thanks,
Right.
sir.
I'm gonna set your bond in each of these cases at a personal recognizance $5,000. And I'm ordering you don't go into any Meyer store in the state of Michigan. You hear me?
No, sir.
All right.
Thank you.
Thank you. Yeah.
I can see you, Mr. Driver.
Yeah. Take his phone. You let him keep the phone? He turned it off. He didn't know how to turn it off. That's why he ran all the way out.
I am deeply sorry.
And you let him keep it? He's good?
I did not have to resort to finding a hammer to smash my phone.
That's what I was gonna do. That's why I want to know. But you let him have it.
I was very thorough and apparently I'm told I moved very quickly.
Oh, you were moving. I didn't know Nemo could move that fast. He was trying to get out. Court calls the case, People versus Thomas Basher.
On behalf of the people,
Judge,
5 cases.
court shall feast the first defender on behalf of Mr. Vasher, who should come.
Is it 5?
It is. I have 4.
Didn't I? I have 4 cases. Did I say 5?
Yes, Judge.
Okay, I lost count.
No problem.
Maybe.
Please state your name for the
Correct.
record, sir.
Thomas Basher. Thank you.
Thank you,
Yes.
Judge. We're requesting adjournment in this matter. Ms. Zinda did turn over some phone calls, I believe, from the last court hearing that I need to play for Mr. Vasher. He does want me to seek a release to inpatient treatment to Dawn Farms in jail and have the court sign an order so he can prioritize and get in as soon as possible.
Okay, for release to patient.
Correct. Sir?
All right.
Yeah, he's not gonna do.
Are the people going to have any objection to release to inpatient?
I would have concerns given the calls in jail to the victim on the TB case that he has.
The Dawn Farms in jail, inpatient treatment.
Oh, you want me to order the in?
Yes, Judge.
You submit an order. No,
Thank you, Judge.
I'll sign off on it.
That's all.
Okay. I thought you were asking for him to be released.
No, Judge.
Okay. Yeah, that's not a problem.
Thank you, Judge. Just a couple weeks, please, and I'll go through the phone calls with Mr. Vasher and try and get this resolved.
Well, the 9th or the 16th, how many?
9th is
calls?
fine. The 9th or the 16th.
We did the 16th, Your Honor.
Because she's not.
Yes, please, Judge.
Probable cause conference will be adjourned April 16th, 2026, 9 a.m. Bond continue. Thank you. I know.
Since it's five. Go to
We
dentist.
just went to court on that.
I'll show you the paperwork I got. So I just look paperwork. Go to dentist, I'll also show you. Thank you, Judge.
There are more conversations going on today. Tonight on Easter. Okay.
Apologies.
Court calls the case, People versus Amber Estelle.
Assistant Public Defender Jay Bellinger on behalf of Miss Estelle, who should be an appearance via Zoom, Your Honor.
Estelle, can you state your name, please?
Amber Estel?
Estelle. I apologize, Miss Estelle.
Oh,
Your
that's
Honor.
fine.
Told me to pronounce it that way.
Your Honor, I am seeking another adjournment on this matter. We are still awaiting some information regarding her Kate Hill sale. I think our goal here is to see about treatment court to transfer over to Hillsdale.
Right, that's what I remember.
In order to do that, we just need to continue on with that case.
All right, so how much more time do you think?
I think I would be asking for about 3 weeks right now. Miss Estelle, your next court date over there is on, did you say it was April 13th?
Yes, sir.
So I don't know how far the court would.
April 13th.
April 13th is their next court date there.
So let's do this then. Is that case that she has the next court date. That's the case that would be going over to sobriety court, or
I believe, yes, that is my understanding, and then we would see about.
try to see if you can got it.
Exactly.
Okay. So here's what I'll do. I'll adjourn this out to April 30th, 2026, 9 a.m. We'll just give you a month, see if that could work out there and
Thank you very much.
what we can do. Okay.
Appreciate it.
Bond will continue.
Ms. Esto, we'll be in touch.
All right. Thank you so much. Have a great day.
You too. Courthouse case, People versus Deidre Woods.
Present on behalf of the people, Your Honor.
Assistant Public Defender, Chinazi Kyriakiru, Your Honor, on behalf of Ms. Deidre Woods, she's coming from the back.
Akin really can't even get somebody from in custody to show up.
Let's state your name for the record. Deidre Woods.
Thank you.
Welcome. Your Honor, we would like to set this matter for preliminary examination, and we'd like to address bond, please.
All discovery.
To our knowledge, Judge.
People have their witnesses available 17 or 7, excuse me. Preliminary examination in person, April 7th, 2026, 9 a.m. before
Judge Perry.
Judge Perry.
Thank you.
Bond.
Oh,
go ahead, Ms. Bond.
As to bond, Your Honor, to bond.
500.
So Your Honor,
It's 10% of 5,000.
okay. Your Honor, I believe her bond right now is currently 5,000, 10%. Unfortunately, Ms. Woods does not have the financial capability to post the $500 bond. She does have a case in circuit court with me right now. We're actually just about to get sentenced on that case. Yeah, Judge, we've worked out. Yep, we've worked out a resolution. She has been coming to all of her court dates. She has been very, very interactive, and she's been keeping in contact with our office. Your Honor, obviously this case is going to for our case, but she has stable housing. She has children whom she's responsible for, and she has been a part of this community for quite some time. I'm sure the court is very familiar with Ms. Woods. I'm asking that the court consider releasing her on a personal recognizance bond. Any conditions that the court will place on her, she indicates that she will be more than happy to abide by all of them.
But you say this is a circuit court case.
That's correct, Your Honor.
What's her bond on that?
She's been out on PR bond on that case.
Oh,
yeah.
Okay. Response.
Your Honor, I would object. You originally requested $10,000 cash surety. This case involves Miss was striking the victim twice in the back and once in his head with a hatchet, profusely from his head, and there was a significant amount of blood the officer saw at the scene, as well as his injuries. Ms. Woods is a regular around the court. She has previous convictions dating back to 2001. Her most recent, she has a 2025 conviction for larceny, 2025 conviction for false pretenses, 2025 conviction for malicious destruction of personal property, 2024 assault and battery, 2025 assault and battery. I mean, the list goes on and on. So at this point, I think the $500 bond is a gift, given that this case involves someone being attacked with a hatchet. And she does have sentencing up with Judge Conley, I believe, on April 1st. And I have concerns that she picked up this new case while on bond for that. So at this point, I would be asking for bond remain set, or in the alternative view, put at the people's original request of $10,000 cash surety.
And just very briefly, if I may, we understand the allegations against my client. I have spoken to her, and I've asked her all those questions and informed her that the court will be aware of that information. My understanding, although I do not have much information, is the complaining witness in this matter was previously arrested based on an assault alleged against her. I don't believe that any charges came out from that particular assault. So there weren't any conditions on him at the time, but Your Honor, it is a domestic situation, or at least this was an issue with a person whom she no longer wanted anything to do with. He's at her home. We don't have any proof as to what has happened. I know that there are some injuries that he may have sustained, but again, my understanding is she states that she sustained injuries as well. Unfortunately, her charges are here. I believe that a no contact order will do just fine in keeping the complaining witness safe, if that's the people's concern. I know she has a history. The court knows that. All of those cases have been resolved. She's either fled out, done significant jail time on those cases, but for this particular matter here, she's unable to post the 500, and we're just asking for consideration on that.
At this point, I mean, her exam is coming up in a few days. I'm going to, at least given the allegations and what certainly I know is what I'm going to deny the request at this time. Certainly, after the exam or at some point it can be raised before Judge Perry.
Okay.
All right. Thank you. Court calls case People versus Cedric Green.
Bring your own Raymond Cook for the people.
3 case.
Assistant Public Defender Jay Bellinger on behalf of Cedric Green, who will be approaching shortly, I imagine. Your Honor, I'm not sure if I turned in a green sheet, but we will be setting today.
You'll do what?
I think I may have turned in a green sheet for that. We'll be setting today.
Really? On all 3? So we're gonna need this.
Mr. Green, will you please name for records? State that a little louder. For the court.
Cedric Green. All right.
There is none yet. He told me I should talk to him over the next week or so via email so I can see about getting you one. Your Honor, with regard to these cases, we are going to be asking to set all 3 matters for preliminary exam at this time. In the interim, for my client's sake, and for the record, I will be working with Mr. Cook as well as Mr. Vangallo in the circuit court to attempt to get him some sort of offer going up.
Got it. All right. Discovery is complete on these cases.
To the best of my knowledge, Your Honor.
Are there witnesses available the 7th?
Your best, Your Honor.
Preliminary examination in these cases will be set for April 7th, 2026, 9 a.m. before Judge Perry.
And then, Your Honor, as to the bond violation, I have had an opportunity to discuss that with my client.
Go ahead.
I'm working on that right now. With regard to the violation, Your Honor, it's my understanding that my client would be admitting to the violation. However, somewhat of an explanation here, and I would be asking to address bond.
I don't have my copy of it. Oh, there it is. Okay. Yes, go ahead.
With regard to an explanation, Your Honor, my client reports that his bag was stolen from him. He had no way to charge his devices. The charger was in that bag. My understanding is that the device was then cut from his leg. I don't know that my client would admit to doing that himself or that someone else did that on his behalf. However, like I stated.
What? So this is part of the explanation?
This is part of the explanation, Your Honor.
Grab his leg and cut it off? Okay, go ahead.
He was, Your Honor, he advises that he advises that he was scared at the time, that he wasn't in his right frame of mind, and that he wasn't also on his medications. And he advises that he was getting high, Your Honor.
Get what?
Getting high, Your Honor. And in that regard, like I stated, Your Honor, I would ask to address bond.
Motion for bond reduction is denied. Defendant admitting to the violation. I will sentence him on a state of the violation. On the violation, I'll sentence him to 7 days, credit 7 days, sir.
And Your Honor, would the court be willing to consider a release to an inpatient treatment or
Send the order. I don't think there'll be a problem, is there?
Your Honor, For the record, the people would have an objection to that, given that he was cutting off his tether. I have concerns that released to treatment, even with the tether order, that would not be sufficient.
But if he's treatment, he's probably not getting high, which is probably part of the reason that the ghost came up and cut his tether off.
I'm not an expert on ghosts, so I can't say that, but.
It was weird or something. I will sign an order.
Okay, thank you very much. Yes, yes. I will get the order in today.
Court calls the case, People versus Rayshawn Ellis.
Alex Jablowski for the people.
Hannah Mackey on behalf of Mr. Ellis, who is approaching, Your Honor. Your name?
Ray Childs. Ray Childs.
Thank you. All right, what are we doing?
Your Honor, we'd like to set this matter for exam,
Discovery is complete.
as far as we are aware.
People have their witnesses available the 7th.
Do our best.
Preliminary examination will be set in person, April 7th, 2026, 9 a.m. before me. But bond will continue.
Your Honor, may I just bond?
Down.
Is a bond condition.
Oh, there you go.
Mr. Ellis is currently on a GPS tether for home confinement, actually, not GPS. And we asked this court if that tether could be removed. He has to go to work. He is allowed to go to work, but also he has to take care of his younger siblings. His mom works 2 jobs, so it's hard for him to get around and do all that.
What else does he have? Because
Also,
normally in a case like this one, he wouldn't be put on home confinement. Pardon?
He also has a curfew as one of his conditions. Oh, what other cases? He has an R&O in circuit court, Your Honor.
Your response from the people.
Thank you, Your Honor. Your Honor, we were initially asked for a 30 bar in this case. Due to the fact that he was on currently on probation in circuit court. This is where he admitted to possessing a pistol while he's on probation, so he felt that safety of the community was paramount, and we would ask that bond be continued with this current condition.
And Your Honor,
Got an R&O that he was on probation for in circuit. It's like, who doesn't have an R&O? And then he's on probation for that, picks up this. And I could see having on but having him on a home confinement, I don't understand why we're confining him to his house.
and that's why I would ask this court to change that, Your Honor.
That was a rhetorical question. Does he have a failure to appear at all?
No, Your Honor, nothing.
He's set to come back and see me on the 7th. So I'm going to order it this time. I'm going to grant the motion. I'm going to order the tether be removed. I dare you not to show up.
Well, so
Hear me?
yes,
Because then we won't need a tether because you'll be back there.
yes, sir.
Am I clear?
Yes, sir.
Thank you.
Thank you so much, Your Honor.
Court calls the case, People versus Kevin Taylor.
Brian Bowling on behalf of Mr. Taylor, Your Honor. State your name for the record.
Morning, Your Honor. Kevin Christopher Taylor.
Hopefully you'll go back the other way. Your Honor, I think Mr. Childers and I came to an agreement on this matter today. We just need a little time to present the paperwork to the court. So I'm asking for an adjournment of the probable cause conference.
Yeah, there's a problem.
I'm aware of the problem, Judge.
Okay, let's talk about that.
Okay. So the report, I'm assuming you're just reading, which I would again assume that is the same one that I have, indicates that Mr. Taylor missed his appointment with Community Corrections on Tuesday. Mr. Taylor indicates to me that he believed that that appointment was today before he came to court, was intending to go there today. Unfortunately, he learned, as I was talking to him yesterday, when I received the email that with that report, that he was actually supposed to be there on Tuesday. So he does want me to let this court know that he's more than happy to comply with anything this court wants him to do with respect to testing, do what he needs to do through Community Corrections. But he's also advised me that he is currently participating in and doing very well in a methadone program, which involves testing already. He tested on
Washtenaw Therapeutics LLC right down in Glencoe Hills. I was actually had my therapy yesterday. Yesterday they drug tested me. They drug test me at least once a week. Usually it's a random test there, but the magistrate said that they would accept the results from there so that I don't have to pay the community corrections fee to do it. That as long as it's through there, my results will be fine. And when I got
So how are they supposed to get there?
that's what we discussed, Judge. I let him know. I've said, well, that's wonderful. You just need to establish all of that with Community Corrections. And like I said, he did plan to do that. He thought he had to be there earlier today. Unfortunately, the date that they gave him was Tuesday.
So did you go there today?
He told me that
I told him to come here because with this report, I figured you'd want to. My understanding is usually Community Corrections, once a report like this is issued, they wait for him to see the court. So if that was bad advice, that's what I give him.
Please. So that from the other place?
I signed a release the day I was released.
He has signed a release with the methadone clinic already. He just needs to get everything.
So we can get those testing results?
They'll be able to be sent.
Do I have any proof that he's in this clinic?
I got my methadone bottle from the weekend right here that shows my
bottle.
Yeah, it's
okay, thanks.
It shows my prescription. It shows the date.
Oh, okay.
You like me to?
So, I mean, he's prepared to go over there right now, Judge.
All right.
Everything's squared up.
Here's what I'm going to do. I'm going to trust you. I don't know why.
I showed up for my last three. Your Honor.
What'd you say?
I showed up for my last three cases, Your Honor. I came here.
Okay, the very fact other cases to show up for.
Yeah. Keep your mouth shut.
No, it sounds good initially. When it comes out. That's a place. Well, adjourn your probable cause conference to the 16th. If you go over to Community Corrections now, you're into. No, he's coming over to do. Thank you. Bond will continue.
Thank you.
All right. Go over there. You know where you're going? Right across the park. Right in.
You should have my last. I got it. You just relax. Courthouse case people versus Corey Wermanen.
Assistant Public Defender Davi Leba for Mr. Warman and Mr. Warman. Can you state your names there?
Corey Warmanen.
Yep. Okay. All right. What are we doing?
Based on information provided to the vote, some people will be dismissed this case without prejudice. I'll file a non.
Thank you.
Any objection?
Of course not, Your Honor. Thank you very much.
All right. Wermanen, case is dismissed. Good luck to you, sir.
Thank you, Your Honor. Like your shirt, by the way.
Yeah, I appreciate that. See, nobody gives me compliments. I like
it too. Great.
Yeah, now everybody's gonna say they like it. All right. All right, buddy. You take care.
Thank you, Your Honor. You know, everybody loves them shirts. What am I doing? Here I am. Hey, what's going on? How you doing? It's the end of the show, y'all. You got nothing else. That's it. I ain't got this turned on. I ain't got that done. I ain't got nothing done. Nothing's done. Don't know what to do this. I think I might be able to figure it out. Ladies and gentlemen, thank you very much for hanging out with me tonight. Ron, Mama, Nado, Julie, everybody. You have been amazing. We started things out tonight with Judge Dad, who has gone viral today. I don't know if you know. but it is the truth. He's gone viral from the little clip that we saw the other night of the lady driving and lying, and him kind of walking off, saying he wasn't going to put up with that type of nonsense. He had had a long day, and that's kind of the beauty of our little compilations that we have here. I think we kind of drew out the day. I can't talk now. We drew everything out just right, so you could see how that frustration was mounting up to that point in time, when the day culminated in a lady calling in, driving from a car. I'm not driving, I'm in the passenger seat. Lady, got a seatbelt. I swear that seatbelt looks like it's on the driver's side of the car, but can you show me the driver, please? No. Ladies and gentlemen, we'll have one more of these tomorrow night. Then we got the weekend coming up. We'll have Weekend Live. So tune in tomorrow night, Friday, same Wolf time, same Wolf channel. That's 8 p.m. Central Time, 9 p.m. Eastern Time for more court cases of the day. And then tune in Saturday for the weekend case review, where we'll compile a bunch of cases that we haven't been able to watch up to this point together. And we'll all watch them together. And then make sure you tune in around 8 p.m. Saturday night and Sunday night both. We have premieres dropping both nights of the weekend. So if you can't make it to the 11 a.m. brunch live, tune in for the premieres and participate in chat. Say hello to everybody. I'll be here. Mama may be here. Who knows? We may not. You may be here all by yourself. Who knows? I can promise you this. The videos that I'm dropping in those time slots, they're longer than normal, and they're all good. So ladies and gentlemen, keep your eyes open. We got good stuff in store. Keep on watching those daily drops that come out at 4 a.m. and noon every single day. I'm your lone wolf Fussel. I'm your curator for these here videos at Court Gallery. And for now, ladies and gentlemen, I'm out. Have a great night. Thank you, Blaze and Cyrus. Thank you, Felix. Thank you, Romantic. You know, there's a Ferris Bueller thing coming up, right? We've got to do our little Ferris Bueller moment. So, before this is a moment of wisdom, just so everybody, it's a little bitty moment of wisdom. Guess who? Guess who it is? Before you judge a man, walk a mile in his shoes. After that, who cares? He's a mile away, and you've got his shoes. It's Billy Connolly.